Let me introduce Gábor. You've already been mentioned several times here in this conversation. He is the director of air passenger rights. So very rightly, right, that you have been pointed to several times. And Gábor Lukács has a PhD in mathematics from York University. And he had different postdoctoral fellowships in Germany at the University of Bremen, as well as Dalhousie University. And after serving as assistant professor at the University of Manitoba and at Dalhousie, then he moved his career to be an advocate for passenger rights in Canada. And he has been leading many successful complaints with the Canadian Transportation Agency, of course, a very important regulator, and particularly looking at how to improve the conditions for carrying and offering better protection to passengers. Because of his advocacy and work for passengers' rights, he has received many awards from the Consumers Association of Canada. He received the Order of Merit for dealing with issues of overbooking with Air Canada. He also, recently in November, the Public Interest Advocacy Center awarded him the Herrigal Award for Transportation in Competition to Connect Communities. And he has been in many cases in courts in Canada, in federal courts of appeals, and the Supreme Court of Canada, also on cases related to air passenger rights, which he has successfully challenged in relation to the issues of transparency and reasonableness and the interests of consumers. So definitely, certainly a very active and successful advocate for passengers' rights. So Gábor, it's all yours, and I'll let you know when you have 5 minutes left.
Thank you very much, and I would like to thank the organizers for putting on this wonderful conference and for commencing a very important task of discussion, because I don't think anywhere else outside academia it would be possible to have this discussion, and it's wonderful to have John next to me, and we're smiling at him because indeed probably in those times he was still grinding his teeth when I was fighting Air Canada. So today I would like to more focus on a narrower topic. I will probably debate, comment on other but in our quite politically polarized and divided Canada, people often debate whether there is or isn't systemic racism in Canada. And in my mind, both sides are missing an important mark. On the one hand, Canada is generally a tolerant and a welcoming country. It rejects, most Canadians would reject racism. But on the other hand, Canadian society undoubtedly has some pockets infected with racism. And in my advocacy for passengers, I observed racism and similar human rights violations in two areas. One is in the immigration system, IRCC, CBSA, and another is the airline industry. And on the former, on immigration, you may want to look up my paper co-authored with Simon Wallace, Ben Perman, and Sean Riag on Canada's extraterritorial migrant interdiction program. But today I would like to tell you about the latter, and more precisely about how airlines may get away with human rights violations that occur on board flights or before, around the time of boarding. I would like to start with an example of David and Ian, who are members of protected minorities. You pick your favorite one, who hold confirmed bookings on flights from Montreal to London via Toronto. They are booked on the same Montreal-Toronto flight and happen to be even seated on their boarding passes next to each other. The agent gate at the Montreal airport refuses to let David and Ian board. She even hurls and insulted both of them to the effect that people with their characteristics should not even be flying. David and Ian know that the way they were treated was wrong, and they are confident that the airline owes them compensation under the Canadian Human Rights Act. It is only when David and Ian see Fiona, the feisty human rights lawyer, that they learn that David, who was flying domestically to London, Ontario, may get compensation, while Ian, who was flying internationally to London, England, may be facing an uphill battle. So how is it possible that two people who experienced the same type of discrimination, same type of issue, even would be seated next to each other on the same plane, yet have so different rights? And the answer relates to the Montreal Convention, and hopefully I don't need to tell here too many people what Montreal Convention is. It has a force of law in Canada thanks to the Carriage by Air Act, and it governs airlines' liability to passengers who travel internationally for baggage delay, damage, loss, and passenger delay, and for accidental injury and death of passengers. The Montreal Convention also contains an exclusivity provision, Article 29, that has often been interpreted by the courts as limiting passengers' remedies against airlines to those set out in the Montreal Convention, and prohibiting recourse to domestic law, to state law. And the rationale being is that they want to create uniformity. The laws, the rules for the airlines operating internationally should be the same among all signatory states. And so the logic goes on to say, since the Montreal Convention does not provide damages for human rights violations, courts have repeatedly held, in my view incorrectly, that the Montreal Convention precludes awarding monetary damages for human rights violations that occurred on board international flights. Of course, you wonder what remedies may be available when you have a racist flight attendant, but not the airline itself being racist, just one person. You cannot send all flight attendants to a re-education camp just because of one of them. The examples that I mentioned so far, however, are not as theoretical or not abstract as it may appear. And I would like to also bring some spotlight on existing court cases that occurred and are affecting human rights to this date on board flights. The first one is George and Judy King, who were African-American couple who held confirmed tickets for a flight from Miami to Grand Bahamas. Their flight was overbooked, and the Kings were bumped from that flight. And the Kings believed that they were selected to be bumped because of their race and their color. But in the US, the Kings' lawsuit was thrown out. They sued for discrimination. It was thrown out because it was held that their lawsuit was barred by the exclusivity principle of the Montreal Convention. There is additional information, but it was Justice Sotomayor from the Court of Appeal at the time who was on that ruling. Another case, speaking of disabilities, Christopher Stott in the UK. He was a person with disabilities, paralyzed from the shoulder down, and permanent wheelchair user who depended on his wife to help him eat, change his sitting position, and even manage his incontinence while traveling. Mr. Stott was booked on a round trip from UK to Zante, Greece, and then back. He advised the airline, Thomas Cook, about his disability and need for accommodation, as he should. And on the way back, on the way out, things were okay. But on the way back, somehow, he was not provided with accommodation as required by UK law and was subject to humiliating treatment due to his disability. And there was no safety issue involved there. So there was no issue with the wheelchair size. In the UK, Supreme Court held that the Montreal Convention's exclusivity principle precludes an award of damages to Mr. Stott that he would normally be entitled to under the UK law because the human rights violations occurred on board an international flight. These, however, are not only Canadian cases. When we look at Michael and Linda Thibodeau, who were passengers on an Air Canada flight where they were not provided services in French, contrary to the Official Languages Act, we see that the problem appears also in Canada. There's a Thibodeau case. They would have clearly been entitled to monetary compensation had they been flying domestically within Canada, but not when they were flying internationally. And the majority of the Supreme Court of Canada endorsed King and Stott and held that insofar as international travel is concerned, the Montreal Convention barred monetary damages even for violations of quasi-constitutional rights, such as those set out in the Official Languages Act. Justice Abella and Justice Wagner dissented and held, in my view correctly, that the Montreal Convention's exclusivity source of remedies applies only to issues which are within the scope of the Convention, baggage and passenger issues that are addressed within it, but doesn't bar claims for human rights issues. And perhaps the most important quote from that decision goes as follows: just as Parliament is not presumed to legislate in breach of a treaty, it should not be presumed to implement treaties to extinguish fundamental rights protected by domestic legislation. This brings us now 10 years later to the recent IATA decision by the Supreme Court, because in the Montreal Convention was being used as a way to challenge Canada's air passenger protection regulations, arguing that because APPR does not require proof of damages It's just a standardized compensation, therefore it was precluded by the exclusivity principle. And the Supreme Court of Canada unanimously held that the Montreal Convention's exclusivity principle, endorsed in Thibaudet, applied only to claims for damages, but APPR standardized compensation was in the nature of a debt, not damages. Problem solved, seemingly. But the IATA decision, although it's a decisive victory for consumers on the compensation aspect, it still muddied the water further when it comes to human rights. Because it was endorsing Thibaudet to some degree, but then also backpedaling on it, saying Article 29 should be understood as precluding actions for damages that share the characteristics of judicial proceedings in courts of law and that seek individualized compensation for death or bodily injury, damage or loss of baggage and cargo, and for delay in international carriage. So after all, this kind of suggests, well, maybe you can seek damages still under human rights, but it doesn't settle the law and it remains outstanding. The recent decision from the Federal Court of Appeal, however, is also bad news when it comes to human rights. Abdallah Zogby was a Halifax taxi driver, originally from Lebanon. He has been a Canadian citizen for many decades. And after a flight attendant overheard him speaking Arabic on the phone, he was removed from an international flight from Halifax to London, UK. He was en route to visit his ailing father. The Canadian Human Rights Commission, bless their little hearts, dismissed Mr. Zogby's human rights complaint about racial ethnic discrimination on the sole basis of the Montreal Convention, of the exclusivity principle. So essentially, if you're on board a flight, forget about it. We're not going to touch it. Ultimately, while Mr. Zogby successfully sought judicial review of the decision, and the matter was referred back to the Human Rights Commission to deal with some charter issues, it was a Pyrrhic victory, because the Federal Court of Appeal held that Article 29 of the Montreal Convention, exclusivity principle, was barring him from recovering monetary damages. So when it was a one flight attendant or a few people involved in this, what kind of remedy may exist to a person in Mr. Zogby's position? Nothing. He just has to lump it. Take it like a chump that he is being thrown off a flight because of his nationality, because of his speaking Arabic, because of his ethnicity. So I'm concerned that this decision from the Federal Court of Appeal has closed the door and nailed it shut for monetary claims for human rights violations occurring on board international flights, whether it is racism, discrimination for gender identity, or a failure to accommodate disabilities. And this is also a concern because Canada may well be in the breach of its obligations under Article 6 of the International Convention on Elimination of All Forms of Racial Discrimination, which guarantees a right to an effective remedy against any act of racial discrimination. So it has to be, some effective remedy has to be, and if you cannot provide money, well, what is the effective remedy then to Mr. Zogby? In many cases, indeed, we're not talking about systemic discrimination that the airline has secret Ku Klux Klan membership. They're business people, decent human beings who have nothing to do with racism from a management perspective. It is just individual people who engage in discrimination, and something has to be done to stop that. So the good news is that Mr. Zogby is currently seeking leave to appeal. He's asking the Supreme Court of Canada to hear his case and decide whether claims for human rights damages are barred by the Montreal Convention. And while I hope that we don't have to wait for too long to get some guidance from the Supreme Court of Canada on this point, this also underscores the need for lawmakers to step in, because unlike the issue of compensation, there is probably a quite big consensus that people should not be discriminated on board of international flights. So it should not be a controversial topic that Montreal Convention should not be precluding or preempting human rights. Because after all, in 2024, international flights should not be a human right-free zone. Thank you.